You're listening to The Wealth Advocates with finance experts John Mickelson and Patrick Jenkins. The Wealth Advocates simplify the financial world and show you how today's events could affect your financial health so you feel confident about your financial future.
Good morning, Wealth Advocates Nation. It's great to be back with everybody. We're at an exciting time this summer of 2022. And as is our normal procedure, from April to June, we talk about estate planning. It's one way that we manifest our value proposition of coordinating your investment plan with your estate plan, with your tax plan, with your income plan, and making sure it fits inside your risk. Today, we're fortunate to have Todd Hallock with Hallock and Hallock. Todd, to get us started, tell us a little bit about yourself.
Sure, yeah. I'm estate planning attorney here in Logan, Utah. I've been here since 1996. Hallock and Hallock is actually myself and my wife. She's also an estate planning attorney with our firm. Law school at Brigham Young, grew up in Arizona, graduated from ASU, and like I say, we've been doing this for close to 26 years now. So, man,
that is awesome. Todd's one of those guys that we send some of our complicated estate planning cases to. We appreciate his support, him being here today. Todd, I'm going to set the stage today. I have a client that came in yesterday. I haven't just been encouraging them to get their estate planning done. I've been nagging them to get it done. Maybe 5, 6, 7 years. Yesterday they come in. She turns to me and says, he has cancer. He has 2 months to live. Holy cow. Estate planning is the first thing that comes to mind. They leave the doctor, they come to the financial planner. What do I do next? Todd, tell us a little bit about estate planning. What is that? Let's educate people on what we're talking about here today.
Sure. Estate planning is trying to put in place an orderly process for your assets to be handled when you either become incapacitated or when you pass away. It's allowing you to plan for how those things are handled, making sure it's done the way you want, when you want, how you want, with the least amount of court involvement and the least amount of professional fees. Really trying to see that your hopes, your goals, your wishes are realized with the least amount of cost possible.
Yeah. Now, correct me if I'm wrong here. These people, they have to do these kind of things anyway. It's a function of, are the courts involved? And maybe more specifically, correct me if I'm wrong here, it is, we've already taken care of the thought behind this. So when you're in distress, when you're distraught, when you're mourning the loss of another, I don't have the emotions involved in making some of these really critical family decisions. Is that a fair statement?
That's a fair statement, yeah. And it also, because of those emotions, tends to be a time when feelings are raw and when with emotions being high, discord and dissension can happen. People can fight over things you wouldn't have expected. It tends to be a battlefield where things are fought over, old wounds are fought over again and again. And so, yeah, it's really that opportunity to make sure that things happen in an orderly, peaceful manner. I mean, I sometimes say our job is to make sure that people feel peace after they've left us, and when their families are going through this process, they feel that same measure of peace.
So, one thing that, with regard to what Patrick just said, a lot of times it seems like people are motivated to get things like this done when they're reacting to something like a tragedy. And, it's hard to say, oh, I'm going to go out today and do my estate planning. Nobody says that. So maybe when should they be thinking about putting an estate plan together?
Yeah,
and from the simple to the more complex, because everybody's a little bit different. It doesn't matter whether you have 10,000 or 10 million. There's kind of a need there.
Right. Yeah, I mean, the joke around our office is, my estate plan is not to die. So far, so good, right? I mean, that's kind of where we start. But yeah, I mean, I tell people it's not about the assets that you have in terms of the value. It's in terms of what you're trying to accomplish, what other things you have going on. You can have an estate that's relatively simple, that's $10 million because it's all in one stock or something. That's a fairly straightforward thing to deal with. You can also have something that's much less than that becomes fairly complicated. And so even as young as 18 years old, all of a sudden, mom and dad can't help you with accessing financial information or dealing with with college. I mean, you might need just a power of attorney as you start to have kids. Who's going to take care of the kids if something happens to you? As we start to acquire wealth, how does that wealth get passed in an efficient manner? Certainly, as you build it and get into taxes and taxable estates and things of that nature, those are, again, triggers. But there's just things all along the way. But I'd agree with you. It tends to be fear that finally motivates people to get across the threshold, because it is an uncomfortable thing to think about your own death. And it tends to be something bad has happened in mom or dad's estate that we're dealing with, or we've got a bad diagnosis, as you indicated, Patrick, or things that are happening in the news. Last year, we saw a lot of people rushing in to see us because of legal changes that were going on, and that was motivating people. But there's probably anybody that's at least 18 years old needs to think about some type of an estate plan.
Well, and you know, my clients hear me say this all the time, but I don't care whether it's big or it's small. Your estate is really important in terms of, you know, how do I make it a blessing and not a curse? Because it can be both. Yeah. I mean, and I've seen people that fight over TVs and books. Yeah. You know, it's amazing how, if it's a clear understanding of how things are to proceed, and it's clear to both those that hold the assets as well as those that are the beneficiaries, it sure makes things a lot simpler. And again, harmony is the key piece.
Right. Yeah. You'd be amazed at what people do fight over. I had a family where two sisters hadn't talked to each other for over 20 years because there was these two decorative items that were kind of a set, and mom had given one to one and one to the other, and they thought they should be together as a set, but neither one was willing to be Solomon and put the baby back together. And so you continue to have that discord. So yeah, absolutely. That's what we're hoping to avoid, is that kind of contention, that kind of acrimony in families.
So Todd, John asked the what question, or the when question. When should we start? Let me ask the what question. What concerns do people bring to the table? What problems do you solve, and how do you do it?
Sure. I mentioned a couple already. Minor children can be a big one. Who's going to take care of our minor children? Disabled children, if they inherit assets in the wrong way, it can create real havoc in their lives in terms of government benefits that are available to them. If we have businesses, who's going to manage that business in the event of our passing? Around here in our neighborhood, farms and ranches are big. How is that succession going to happen? Certainly taxes can be a big issue. People are afraid of probate. They don't always know what probate is, but they want to avoid it. And so that can be that's one of the what's that can be driving people in there. So those are a handful of things that can be what we're trying to take care of as we manage an estate plan.
Let's talk about that awful P word.
Okay.
And maybe define it a little bit. There's really three categories, if you will. There's you don't have anything, intestate. You have a will, you have probate, you have a trust. Maybe you could walk us through all three of those phases of estate planning. Sure.
And I'd probably add a fourth one in there. So intestacy is we don't have anything. We have no will. We have no, and testacy means death, when you die. And so intestate is the process of not having a testamentary instrument that allows us, like a will, to go through the distribution of your assets. And in that setting, we're relying solely on what state law is in terms of who's going to be in charge and where it's going to go. And every state can be a little bit different. I'm licensed in 3 states, Arizona, Idaho, and Utah. All 3 of them are a bit different in what will happen when someone dies without a will or a trust. And then that's going through the court, and the court is making those decisions for you. I would kind of have a little in-betweener there and say beneficiary designations.
Okay.
Most people that, even if they don't have a will, they've at least hopefully done beneficiary designations on retirement accounts, investment accounts, life insurance policies, things like that. Sort of the first step that people take is doing a will. And a will is a death instrument. It's not effective until you die, and it's only effective once it's gone through the court system. And that's what probate is that court system that allows us to move assets from deceased individuals to living individuals. That will is your opportunity to say who you want to be in charge and who will receive those assets upon your death. A trust, very similar to a will, in what it accomplishes, it just does so without the need of going through the court process. So it's an opportunity for, again, you to say who's in charge, who gets what, and then do so without involving the courts in the process. The other benefit of trust versus will, I guess, is and trust can get really specific in terms of the goals you're trying to achieve, but trusts are living, or can be living instruments that are effective while you're alive. So they can also help if somebody becomes mentally incapable of managing their affairs.
One other thing that along those lines, it's amazing to me that the first stage is that beneficiary stage in your accounts. There are only 4 places you have beneficiaries, and that's life insurance, annuities, retirement plans like IRAs and 401ks, and trusts. And so those are the ones I tell people when they come in, I know you think you know where all those are, but you ought to look at them every year, because it's amazing to me how many times the beneficiaries are not what they thought. And there's always an article in the news every few years about some ex-spouse that ended up inheriting all the retirement assets because the guy forgot. Yeah. And so it's really important that that's done frequently. Check the beneficiaries and double check them.
Yeah, I'm glad to hear that you guys are doing that. I mean, I think a good financial planner can make all the difference in the world on estate planning, because those beneficiary designations, if they're not done, or if they're inconsistent with what you're doing in other places, it can create all sorts of problems. I'm dealing with a situation right now where the lady's husband passed away before her. That was her sole beneficiary on her life insurance policy. She passes away. Oh, wow. We don't have a beneficiary, right? So now we're going to probate to get these assets for the family that otherwise would have passed without need of that cost or delay.
Yeah.
So Todd, you walked us through 4 stages of estate planning. One is no estate planning.
Yeah.
When do I need a will? When do I need a trust? That's a common conversation we have here.
Yeah, and that's a tough question. I think there's no particular dollar figure I'm looking at. That's what a lot of people come to us and say, I'm worth this much. Do I need a will or a trust? To me, at one level, it's personal choice. Do you want to avoid probate at death? If one of your goals is avoiding probate at death, then a trust is going to be the answer. If one of your goals is, I prefer privacy versus a public process, then a trust is going to be your answer, right? Probate is a public process. The will goes through the court system. All of that's open, public record. If you want more privacy, there are certain triggers where I'm going to say, you absolutely need a trust. Blended families would be an example of a situation where a trust is almost mandatory. If you own assets in more than one state, here in Logan, where we're so close to the border, it's not uncommon for us to have people with assets in Idaho and in Utah, or frankly, they've got their winter home in Mesquite or down in Phoenix. If you've got assets in multiple states, that's going to be a time where a trust can benefit, because if you have those in multiple states, you can end up doing probates in multiple states. The dollar amount net worth question really gets into taxable estates. If you start floating into that situation where your estate is taxable, and right now that's just over $12 million per person, those estates really benefit from trust because of some of the things we can do. If you're trying to do asset protection planning, trusts are going to be the vehicle we're going to be looking at. So those are the kind of things we're looking at in deciding wills versus trusts.
Really good. Okay. Yeah. The most common thing we see with new people becoming clients at Wealth Advocates is no will, no trust, no estate plan. But the second most common is, I have a will, I have a trust, I haven't done anything with it, I haven't funded the trust. Walk us through what that means and what should go in a trust.
Sure. Trust funding is the word we use for making sure that assets are controlled by the trust. If I had my little whiteboard that I have in my conference room, I would at this point draw a picture of you of a bucket, and we show assets going in while you're alive and assets pouring in at death. That's trust funding, making sure your beneficiaries are aligned with your trust plan, making sure that assets that you can put in the trust presently are there. anything that's not in the trust at the time you pass away and is not otherwise passing by a beneficiary designation likely will be subject to probate. And so then if you've gone the trust route and you still have to go to probate, we've kind of missed on one of our goals. And so that's what funding is. It's making sure that the trust is kind of the coordinating mechanism of your estate plan, and that everything is moving into that trust either while you're alive or at your passing.
Awesome. Now, John kind of hit on this, but maybe you could reiterate it. What kind of things don't go in the trust as part of the funding mechanism?
Yeah, really, pretty much anything can be put into a trust with one major exception, and that's going to be retirement accounts. Retirement accounts have to be owned by the individual while they're alive. So when we send out our questionnaire and somebody comes back and says, my wife and I own this retirement account together, I know that's not right, because a retirement account can only be owned by an individual, the original account owner, while they're alive. A trust can inherit a retirement account on death, but that's really the main asset that can't be held. And the reason is the taxation of those retirement accounts. And you don't, I guess you don't even technically own the retirement account yourself. There's a fiduciary that owns that account and owns it for your benefit. And so that's an asset we can't move, and we have to, again, coordinate the beneficiary designations. But really anything else, houses, cars, in other non-retirement investment accounts, businesses, all of that can be held in a trust.
Gotcha. Okay.
Go back to, that's ownership. In other words, who has the retirement account? Talk a little bit about the beneficiary of the retirement account as it relates to trusts.
Yeah, this is a really important question right now. We've just gone through a sort of a period of upheaval in death planning for retirement accounts. We had the Secure Act back in 2019 that became effective in 2020, and now currently pending before the House, we have Secure Act, or excuse me, not pending before the House, it's passed the House, pending before the Senate, Secure Act 2.0. And those have really changed the ball game in terms of how we deal with retirement accounts at death. A trust, if it's not properly drafted, will put us into the category of non-designated beneficiary. And a non-designated beneficiary will have to have all of those retirement account assets out within 5 years of the date of death. That means a couple of things. One, if it's a Roth plan, then you're losing a period of tax-free growth. If it's a tax-deferred plan, that means that you're going to have money out quicker, increasing your gross income for a year, increasing your tax rate. The money's getting taxed quicker and usually at a higher level. And so coordinating and making sure your trust is properly drafted becomes key with retirement accounts so that you can get the full benefits that the law allows in terms of tax deferral or tax-free growth.
Mm-hmm. Yeah, see, and that's excellent, because that's one of the challenges is one of the complications is that rule change makes us as financial planners have to look at every retirement account a little bit differently. If they're prior to 2020, we have to look at it and say if you're inheriting it, you only have, what the rule was before is you could take it out over a long period of time, over a lifetime.
Yeah.
After 2020, that changed, right? It went to 10 years. So now they're saying, hey, we've got to accelerate that. You can't stretch it out as far. That's not as good. So remember when we're talking about distributing money from the retirement account, what we've generally said is everything you have should go in your trust, except the retirement account, because that would become taxable if you have to take it all out and put it into the trust and maybe spread it over 5 years. The exception is if you put a spouse first, for example, they get to inherit it as their own account, so you're not forced to take it out and pay the tax. And then the second thing is when it's inherited, then it can be spread over 10 years instead of all a shorter period. Is that accurate?
That's accurate. It gets. I tell people I've got a flow chart that helps us decide these things, and you can't even see any white on the flow chart. There's so many if this then this, and so exactly. I mean, the wife is always or the spouse is always the most favored person. They're going to be what we call an eligible designated beneficiary, which means they can continue to extend it over their lifetime as opposed to the 10-year rule. Plus, they even have some additional benefits of the timing. They can potentially even not be required to take anything out until they turn age 72 in under the current law. And that's one of the things that might be changing, is that age might be going up to 73, 74, 75 over the next 10 years or so, if Secure 2.0 passes, which it looks like it will. But yeah, the spouse has this really priority position, and so we always want to make sure the spouse is first, and then contingent beneficiary will depend on the status of those people that you're wanting to name. Are they disabled? Because that person can continue to defer over their lifetime. Are they a minor? And minor under the statute is 21 years old. There's different ages of majority in different states, but Congress has said 21 for this purpose. So depending on the status of that contingent beneficiary, whether a trust is in place or not can make a difference in how we do that. And so it becomes really crucial to have you guys in the mix as financial planners, because again, the beneficiary designation will control over everything else. It doesn't matter what I've done in the estate plan. If the beneficiary designation is something different, that's what's going to control. So it becomes crucial.
Yeah. So in that scenario, where you say, okay, spouse becomes first beneficiary on the retirement account. Generally speaking, we've said put your children on by name as contingents, which I know that there are exceptions for that in the trust. And maybe to illustrate the point, think of, like, I've got one client that has a child that is special needs and is on Medicaid. So talk around kind of what exceptions would you see?
Yeah, so with the child with special needs, it used to be pre-2020, you wouldn't want to have your special needs child touch that retirement account with a 10-foot pole, because if they get the money, it can make them ineligible for their needs-based government assistance, the things that are paying for their medical treatment and the different things that most people couldn't afford without that help. And so you would point those retirement assets to the non-disabled children and have the disabled child receive different assets, maybe a life insurance policy or something like that. Post-Secure Act, the script is kind of flipped. Now the disabled child really has a heightened benefit in receiving that account, and special needs trusts, which are trusts that are set up for receiving assets for the benefit of a disabled individual in a way that will allow them to continue to be eligible for those needs-based government benefits. Those are treated as if they are that same individual, so they have that same ability to defer taxation over the lifetime of the individual as opposed to just 10 years. And so now it's almost better to point them towards that child, but you want to do it in the special needs trust, because if it just goes to the child, now we've got a problem with eligibility. And so that trust can become vital in that circumstance. The other thing to be mindful of with trust, if you start working with us on this kind of a project, we'll start talking about accumulation trust versus conduit trust. Conduit trust is going to be a trust where that distribution from the retirement account comes out, basically goes through the trust and then right out the other side to the beneficiary, so that that beneficiary is immediately receiving that distribution. Accumulation is we're going to get the distribution from the retirement account into the trust, but then it's going to stay there. The important thing to understand is trusts tend to be taxed at higher income tax rates. And so when we're doing accumulation, we need to be taking into account that we're choosing to have the money taxed at a higher rate. And so there's a lot of stuff.
Yeah, tax sensitivity is a big deal in that case.
Yeah.
So I can't help but share one example, and I've asked permission to share this one, but I had a client who had a brother that was mentally ill and still lived somewhat independently. And he liked to go up to the Idaho border and buy lottery tickets. Now, he was on Medicaid, and he won.
Oh, sure.
Of course.
So it wasn't $1 million, it was $10,000. But the fact that he would receive the $10,000 would have made him ineligible for his Medicaid. Correct. So he had to disclaim the prize and hand it back to the state of Idaho, which he was not happy about that.
Yeah,
it was a hard one to explain to someone that really couldn't understand it.
Yeah, absolutely. So, $2,000 is your limit, if that's all you can have at any given time.
Yeah.
So.
Wow. Hey, I want to go back to Secure Act 2.0 because there's a lot of nuances that are coming to fruition right now that are different than 2019 and significantly different than post that, I think it's a good time to point some of those out. You mentioned the 5 categories of beneficiaries that are exempt from this, spousal being one of them. I want to talk a little bit about distribution that occurs, and it really speaks to the need for the partnership between the attorney and the financial advisor. When we set up different accounts, say an IRA versus a Roth IRA, you set up an IRA, spouse passes as well. When it goes to that next generation, they have to liquidate every single year by the 10th year. So 10% really every single year, unless it's a Roth. A Roth, you don't have to take distributions every single year. You have to have it liquidated by the last year. And so in all this, not only are we saying how should the assets be set up and who should they go to, we need to contemplate how the income will be distributed and dispersed to the next generation. Any comments or any insights on that?
Yeah, I don't envy you guys. The rules have gotten extremely. I mean, and you kind of hit the high levels, but even within that nuance, you get into did the person die before they hit the required beginning
RBD,
date?
Yep.
So if they died before the required beginning date and it's a tax deferred as opposed to a Roth, you can wait until year 10 to take the whole thing out. If they died post RBD, and RBD is going to be different for different people, right? I mean,
like today, it used to be 70 and a half. Now it's 72. It's going to be 73 in 2032. It's 75. Correct?
Correct. Yeah, we go to if assuming this passes, right? Again, Secure 2.0 is not passed yet, and we also had new regs that came out just recently. And
regs is lawyer speak for regulations.
Yeah, regulations. Yeah. Sorry. We just had new regulations that came out on the original Secure Act that have also changed the dynamics. Until about February, we all thought we could just wait until year 10 on any of these things. Now that's not the case anymore. And so I know you guys are having to scramble, at least for people for this year, maybe for people for past years, to get that out. So it is. Really challenging right now. I suspect, like everything else, we'll find processes and ways to make sure that people are being compliant. But this is a time when, especially if you're in that category of someone who's passed away since 2020, January 1 of 2020, you really should be talking to your financial advisor, tax accountant, making sure that your distribution schedule is timely.
Really it. I mean, the challenge right now is it's shooting at a moving target, and most people are completely unaware. So, I mean, that's where I hope they rely on us to say, okay, well, how does this apply to me?
Yeah, because the failure to do, what's the penalty again? It's currently...
Well, hang on. That's a point worth talking about because we missed one. I had one client, we missed their minimum distribution last year. And the tax is 50% of what you were supposed to take. That's the highest tax rate out there. So if you're supposed to take $10,000, you owe the IRS $5,000 for missing it. Now it's changed in 2.0, thank goodness. It's down to 10% of what you were supposed to take. But it really comes down to the required minimum distribution exists because the government wants their money. So in that vein of taxes, Todd, talk to us about estate taxes, specifically annual gifting and estate tax exemption.
Sure, but before I do, can I just respond to one thing you said there, and that is the other thing that's important is what's in that retirement account, right?
Oh, yes.
I mean, the retirement account's really just a wrapper, and it can own just about anything.
If it owns land.
If it owns land, this is going to get really challenging to have to distribute 10% of the land year after year.
A nightmare. Absolute nightmare. How do you do that?
Yeah, nightmare. So
if it's a non-liquid asset, if it's a REIT that doesn't distribute 10% per year,
Yeah. So again, got to see your people that are helping you with this because it's going to be really challenging to do it on your own.
Yep.
Estate taxes, we're again unsettled times, right? In everything.
Moving targets.
We without doing too much of a history lesson, we've been kind of on this upward trajectory since 2001. In 2010, a law was put into place that put the exemption at $5 million per person, indexed for inflation, so it was going up a little bit each year. Then in 2017, another law was put into effect that became effective in January of 2018 that doubled that $5 million to $10 million per person. And indexed for inflation from that point, from 2010, which puts us today at a state tax exemption of 12.06 million. What that means is that an individual can have assets or a net worth up to 12.06 million before they'd have to start paying estate taxes. It's kind of like a coupon that you get to use. The taxes begin with $1, but you have this coupon for 12.06 million. And for a husband and wife, that's shareable. So for a couple, we can get double that amount. The tricky part is that law that was put into effect in 2017 was not permanent. It was a temporary law that will expire, or what we call sunset, at the end of December 2025. And so if it does sunset, then we're going to be going back to what we had previously, the 2010 law, which will be the 5 million per person. So instead of having 24 million for a couple, we may only have 11 or 12 million, which sounds like a lot, but you'd be surprised at how quickly sometimes people can start flying over that if they own land or apartments or different things like that, and life insurance and all that stuff coming in. And so last year we went through a really big period of instability as Congress was actually trying to accelerate that reduction date to January 1 of this year. That didn't end up passing. And so, without getting into political banter and political speak today, we probably won't know what's going to happen until 2025. My guess is we won't see anything major going on that front until that's likely to pass until we get to 2025, and depending on the lay of the land politically, whether they can get something done, we'll see. But that's something. If you have a little higher net worth, really need to keep your eye on. Those estate taxes are 40%. Right. So if I have an estate that's worth 13 million and I've got a 12 million exemption, I'm paying estate tax on $1 million, 400,000 due 9 months from the date of death. So.
Yeah.
Todd, to wrap us up, why don't you walk us through a couple steps we need to go through when we begin the planning process?
Sure. Probably the first and most important thing when you contact our office is to, that's probably the first and most important thing.
Call the office.
Call your attorney and get an appointment. It's hard to get across that threshold, I know, for people. And so once we get them there, we try to wrap them up and keep them moving through the process. But the first thing we're going to want to do is get a sense of your net worth. So having an understanding of what you own, and at some level what it's worth, is going to be really important. Having a sense of who you want to be in charge of things is going to be crucial. You don't need to know all of the details, but you need to know some of those big picture things to help us through. Are there children or beneficiaries that have challenges that we should be aware of? But the first thing we do is send out a questionnaire that hopefully tries to help make it easy for people to think through this process, and then stick to it. I mean, the thing that I worry about the most is we'll have people that come in, get started, and then they feel like they've done it, but they haven't. It's not done until it's signed, and so you gotta keep going through until finish. And it's better to have a plan that's maybe 70 or 80% of what you want than no plan at all, and then to continue to tweak that plan and get it closer to exactly perfect. I don't know that anybody ever gets a perfect version of what they want. I mean,
well, signed and funded. I mean, a lot of times I've seen people get the trust, but they don't put anything in it. That doesn't do you any good.
Yeah. It's no good for me to be, and this just recently happened to us, to be in your hospital room signing documents, because we may have a signed trust agreement, and we can get things there ultimately, but it's going to be a lot more challenging because that funding hasn't happened.
The other point of preparation that I've suggested to clients is beyond the structural things that we're talking about, is think about your particular family. And I always joke that everybody's family is weird. No one thinks it, but it's true. We're all unique. So in your unique family, think about who can handle money. I mean, when is it good for them? When is it not? Yeah. Is it better to have, a stretched out period of time to help them over a long period, or is it something where just hand it off and let them go? But think about, the uniqueness of your family and what you want that to do for them.
Yeah, absolutely. I mean, that's one common misconception, is that really all you do in estate planning is say, everything goes to my kids when I die. But that's far from the truth. we're gonna have that plan that's going to deal with you while you're alive and able. It's going to deal with your incapacity. It's going to deal with what happens when the first spouse passes away. And then each child can be treated like the individual they are and what's best for them. And thinking through which of your children or maybe a professional would be the one to manage that process. Some families struggle to get along. Putting people together that are going to butt heads at every level might not be the best solution. And so, again, really thinking through the personalities, the makeup, the nature of the assets. If you've got this golden goose that lays these golden eggs, why would you want to just blow that up and divide it 6 or 7 ways or 5 ways or however many kids you are? Why not look at a plan that maybe keeps that income together and that can perpetuate through the generations? So I agree with you wholeheartedly.
Yeah. Really good points. Really good discussion today. John, any final words?
Just be prepared. I mean, this is just the case where it's easy to say, oh, I'll get to it. So the one thing I would say is for myself and everyone else, revisit it at least once or twice, every year or two. So that what you think will happen actually will take place. Because I've seen estates that really did anticipate quite well, communicated quite well, and at the point it just sailed. It just went right through the way it was supposed to. I've seen some that they thought they had it all worked out, and then there's 2 or 3 things that didn't get done the way they thought, and just complicates what would have been a very clean plan. So preparation and get with people that know how to direct you, whether it's us or not. Just get to good professional help.
Great conversation. Todd Hallock from Hallock & Hallock, one of the best estate planners in the state of Utah. Thank you for joining us today. Thanks for being part of our podcast. We hope you got something out of it today.
Thank you for listening to The Wealth Advocates. Join us every month by subscribing on Apple Podcasts, Spotify, or Google Podcasts. You can also look for The Wealth Advocates on Stitcher and YouTube. Want more information about today's topics? Reach out to John or Patrick directly by calling or texting the Wealth Advocates office at 435-754-7888. Learn more about the Wealth Advocates and how they can help you by visiting www.wealth-advocates.com. Securities offered through registered representatives of Cambridge Investment Research Incorporated, a broker-dealer member FINRA SIPC. Advisory services offered through Cambridge Investment Research Advisors Incorporated, a registered investment advisor. Wealth Advocates and Cambridge Investment Research Incorporated are not affiliated.